Welcome to the Wellness Law Podcast, where wellness and the law meet for contemplation and collaboration. This podcast is brought to you by the Center for Health and Wellness Law. I am your host, Barbara Zabawa. Welcome, Darryl Rogers, to the Wellness Law Podcast. I'm so excited that you're here to talk to the audience about licensing issues and different nutrition issues that you deal with at the Holistic Council. So you are an advisor to the council, and the Holistic Council serves different types of practitioners, wellness practitioners, and in particular, you guys are very expert on nutrition laws, and you watch those different state laws closely. And I encourage everyone to visit the Holistic Council's website and use it as a resource because they do incredible research. So welcome, Darrell.
Hi, Barbara, and thank you so much for those kind words.
So let's dive in. How long have you been doing this kind of work?
Job on Capitol Hill was in September of 2001 when I was still in undergrad and got an internship. But I've been involved specifically in kind of health and wellness policy and advocacy since about 2010, when I started working at the Alliance for Natural Health. And then I was at the Institute for Integrative Nutrition. And now I assist the Holistic Council.
Wow. So 15 years in this particular nutrition advocacy work. What kind of efforts are there to restrict nutrition practice in the states?
Organizations and entities and professions that want to put a fence around who can say what they can say, and then confine certain portions of nutrition practice to just people that have their either degree or their certification. And those efforts continue. Mainly it's the registered dietitians and the Dietetic Association and their state chapters are very interested in ensuring that their members and membership are the only ones that can provide nutrition services. We've seen generally a pretty big change in their approach over the past few years, which actually has been more advantageous to nutrition practitioners or holistic practitioners. But we still have significant concerns about their bill's language and how that legislation, if it ever does pass, how those laws would be enforced.
One thing I didn't mention is that I just finished a research paper on First Amendment speech protection for unlicensed wellness coaches, and I looked very closely at the Florida case decided at the 11th Circuit, the Heather Del Castillo case. And I was just wondering if you had anything to say about that case and First Amendment protection.
Yes, and actually in that case, which I know quite well, the state, when they tried to find evidence of harm, used a case that there was actually a cult of dentists that were conspiring and engaging in illegal activity. And they used that as an example of how we need these laws, but it was literally a cult of dentists. It was so far off the mark. It was laughable. I do want to look into that Indiana case. It sounds very fascinating.
It was.
And my general understanding is the arc of the understanding of speech in 2025 is that it should face fewer regulations and not more.
Mm-hmm.
And I think that's not a controversial statement. I think just generally, if you look at recent decisions, both federally and in state courts, there's more deference being paid to the Constitution and to individuals. What does that actually mean to a holistic practitioner or a provider of nutrition coaching and services? Something, but not a lot. And what we often advise are our students and the graduates of the programs that are members of the Holistic Council is to be upfront and honest about your services, to be upfront and honest about your education, to not use terms that are kind of regulated and people understand them to be used by medical professionals. So, treat, cure, diagnose. We advise practitioners to avoid using any disease states, in their advertising or speaking of their services. what we don't want are our holistic providers to be confused as if they were a practicing medical practitioner, because they're not.
Yeah.
And the world of wellness, the world of health, and the world of nutrition is so incredibly impactful and broad that we want people to use the wellness terms. We want people to use the nutrition terms. We want people to optimize and thrive and succeed and find, health and wellness and unique paths, because people are kind of turning away from the medical paradigm and we don't want to mimic. And so, one of the things we do advise our practitioners is to be mindful of those terms, to use lower risk terms. And it's a safer way of providing nutrition services without running afoul of those specific terms that do exist for other providers.
Yeah. That's very interesting. Another thing I wanted to talk to you about is something I'm planning on writing about next, which is whether medicine should basically own the concept of prevention. I spoke with a nurse practitioner recently, Dr. Frat Lemondre, and she was talking to me about how people who practice medicine don't really get taught on how to truly prevent disease. And if you look at all of the state practice acts, the medical practice acts, part of the practice of medicine includes preventing disease and illness. And yet, the way our healthcare system is set up, it doesn't allow physicians in particular to prevent disease. The whole concept of prevention, for example, in the Affordable Care Act, is to just screen for the presence of tumors and take lab tests just to identify whether you have a disease or illness. And that's considered prevention. And yet, what people really want when it comes to prevention is much more holistic and lifestyle and environmental-based care that physicians, frankly, just aren't equipped for all kinds of reasons to provide. And yet wellness is. And so if we're going to limit the word prevention to the practice of medicine, and yet the people who practice medicine can't deliver on those services, at least the way that patients really want those services, then legally we should open up that concept of prevention to allow others who aren't licensed to practice medicine to allow them to engage in the prevention of disease and illness.
But it's interesting that a nurse practitioner noted that, because I've looked at nurse practitioner scopes of practice and have spoken with a number of them. And the way they've sometimes been able to perform their nursing activities and not run afoul of medical practice laws is to simply use a different word, but it's generally the same conduct. So a nurse practitioner generally, and I'm not saying like specifically, like different states have different definitions, but in many states, like diagnosing is not allowed by nurse practitioners. But what they can do is, and so I understand the prevent, because I have seen that and very well aware of it. It's usually the prevention of a disease.
Mm-hmm.
So what we advise generally, our member schools, we can use terms and phrases that communicate factual and honest information that eating and exercise and well-being can reduce the likelihood, of conditions, of ailments, right? But we're not using those, what I call high risk words. And, when I've learned more about if a state ever does take action against a practitioner, a non-licensed practitioner, what they'll generally do is they'll have the code in one hand and like their website in another. And they're just looking at the words. They're doing this. And if there's more than a few words, we'll go, I guess that's it. I guess that's what they're doing. Mm-hmm. So, you as an attorney, like what you say you do is what you do, even if that's not what you're doing.
Mm-hmm. Mm-hmm.
And, you can have the most general and basic educational program for multiple people, which I think we all agree is protected by the First Amendment. But if you advertise that program will treat or cure or prevent a disease, the state may say, well, this says you can't do that, even though that's not kind of what you're doing. You're saying you're. So we like to recommend to our practitioners to avoid those high risk words and lower your overall risk profile. That's the Food, Drug, and Cosmetic Act. I sometimes use the world of vitamins and dietary supplements, which I was a lobbyist for some time. There is a whole world of language around improving the structure and the function of the body that can really communicate some pretty effective about what you're doing without using medical terminology. So I think it is possible for non-licensed practitioners, and I understand where you're coming from on the academic side. Prevention should be allowed. The Holistic Council generally approaches it. How do we lower their risk, but still communicate to the public that they're doing something beneficial?
Yeah. I don't know if it's just an academic argument, but I think it's also a legal argument because right now the scope of practice for medicine encompasses prevention. And if medicine can't deliver on the kind of prevention that people want, primary or secondary, or sometimes even tertiary prevention, then wellness can step in, should be able to step in legally and offer some long-term primary, maybe secondary prevention services to consumers.
It's a very good point. And I would say that I'm trying to remember the name of the woman. Like, she was one of the first to really delve into the scope of practice issues around MDs. And she said that they got to the mountaintop first and called everything theirs, essentially. And we've actually seen the attempt at the medicalization of prevention in some of these licensing bills that the dietitians are attempting to pass. So they'll have an exemption section that says you can provide tertiary prevention, to conditions. But then the hell is tertiary? You have to look it up. Well, it's nutrition services or wellness services to an individual before a nutrition condition is identified. And so when I actually have the dietitian's lobbyist in front of me, I say, so an individual can perform weight loss services to somebody who's not yet obese or overweight. Is that what you're saying? Like, they don't want to say yes, but that's what it says here. But if a person, let's say, is overweight and they do want to lose weight, an individual communicating to them would be providing a prevention service or reduce, like a prevention of disease, but also reversal of disease. And so we've been very, very mindful of trade groups and also, everyday conditions and easily reversible lifestyle indications. It's so easy for trade groups and professionals to say, oh, you have that indication. That is now officially a disease, and therefore only I, by I mean people that hold my degree or my license, can even communicate to those people. And we think that's pretty antithetical to improving health and wellness. We think it's definitely not an argument that is being well received. I think on both political spectrums, there's definitely an enthusiasm for independence of thought and a marketplace full of providers and practitioners. And I think that's what's really wanted. And that's what hopefully we continue to see. One other point there, I think since COVID, people have become a whole lot more comfortable with testing themselves at home for a variety of things. And now you see there's an amazing amount of services and do-it-yourself and direct-to-consumer testing that wasn't available just 10 years ago. And so what I think is a very strong undercurrent of this is that people can now order online tests and even services that used to be reserved for just medical professionals. They can now do it at home and get those results, whether it's hair follicle or urine, all kinds of bodily fluids. You can now mail and get an amazing amount of information back about your health status. Those were reserved for just medical professionals inside of hospitals, labs, and clinics. And so there is a democratization of healthcare and wellness services that didn't exist. And I think that's changing the paradigm significantly.
The law needs to catch up. It needs to allow empowered consumers to take ownership of their own wellness journey.
And every once in a while that law intrudes in this greater river of independence and accessibility, consumer practices, and it stands out. And I think the Heather DiCastillo case in Florida, Steve Cooksey's case, which was like the first big one in North Carolina, I think that really away a lot of the layers of the onion, and people saw how ugly licensure can be. We're talking the state dietetics board in North Carolina was running undercover sting operations at health and wellness centers in the state and trying to entrap non-licensed providers. And there were 50 or 60 investigations open. And once it was uncovered that Steve Cooksey was just one of many, the state board was facing a lawsuit, legislative action, bad media. They had to change their tune. So I think it's quite reasonable to say that the arc of this is greater freedom and greater accessibility.
Yeah.
But the law still has to,
Right.
the law still has to catch up to where people are, industry is, and science.
So, how big of a risk do you think there is for unlicensed coaches or other unlicensed wellness practitioners to do what they do without getting disciplined by a licensing board, for example, without getting a letter from a licensing board telling them to stop what they're doing?
Well, we advise our member schools and their students to get professional liability insurance. It's a reasonable thing to have when you're working, especially as a solo practitioner. And I would say insurance companies do a very good job of assessing risk because that's what they do professionally. And a significant amount of professional liability coverage can be had for like hundreds of dollars a year. The professional risk assessors believe the risk is very low because you can get like $1 million worth of coverage for like $200. So that's a really great indicator of the risk that's in the marketplace. I would also say that we hear from practitioners when they face some sort of enforcement action, and we can thankfully say that it's rare and it's becoming rarer, but we still want practitioners to be mindful of the terms and services they advertise to ensure that they have professional liability insurance and that they communicate honestly with the public and their clients about services and expectations and training and just being a good business person and a trusted coach and partner in somebody's wellness. And then also that reduces the likelihood of civil liability too, if you have a client that's upset. So all of these things kind of build into a very low risk method of practice.
Yeah. And I like that you use the word trust. That's one of the things or concepts that I'm trying to really boost in the wellness field, creating some kind of standard and ethical practice in wellness, because the wellness industry is constantly battling against this stigma that exists from conventional science and medicine. And in fact, right now I'm reading or reviewing a book that's written by someone who's very much opposed to the wellness industry and basically views everyone who's involved with the wellness industry on some level as selling snake oil and gimmicks. And I'm trying to create a community of wellness professionals who want to be seen as trustworthy and want to be doing right by their clients and the wellness community at large.
It's unfortunate. And I don't know where they've been wronged by someone, or maybe they just have an amazing amount of bias, but there are notable kind of programs that provide a private credential when you complete them. There are national board credentials and certifications individuals can achieve. And then every state has rules and laws about conduct for businesses. And also, I would say that this community polices itself very, very well. That if a practitioner is clearly making claims or being disruptive or not kind of reflecting the community accurately or well, they'll hear about it, on social media or personally. So safe place to practice. So as long as you utilize the tools that are available for practicing, many of which are found on our website, but also through the programs that credential and certify health coaches and nutrition practitioners.
That's great. I want to thank you so much, Darryl, for giving us your expertise and everything that you do at the Holistic Council. So, how can people support the work that you do and get access to more information about all of the wonderful resources that you gather as being a voice for the wellness industry? Your work.
Go to our website, take a look at the programs that are members of the Holistic Council. And if you graduated or completed a program that is not a member of the Holistic Council, please reach out to them and let them know what a valuable resource this is to not only you as a graduate, but also the community. So please do that. And if you graduated from one of the programs that is a Holistic Council member, email that program and let them know, or call them, reach out to them on social media. Just let them know that you're really thankful that they are, because those programs have contributed to the council and to the overall effectiveness and growth of the entire community.
Thank you for that guidance, and thank you for being a guest on the Wellness Law podcast today.
Same to you, Laura. We're going to do outstanding work.
Thank you for listening to the Wellness Law podcast. You can find more wellness law resources by visiting the Center for Health and Wellness Law website at www.wellnesslaw.com, where you can also subscribe to our newsletter and follow us on social media. Until the next episode, stay well, stay hopeful, and stay legal.